Dear all, once again I welcome you all to the part 2 of the presentation on legal amendments related to victims of crime in India. In the part 1 of the presentation, we have gone through the CRPC Amendment Act 2008. Now we have to see the Criminal Law Amendment Act 2013. This Amendment Act is also a very significant piece of legislation in Indian legal history. I am very much sure most of you would have heard about the Nirbhaya gang rape incident in Delhi. This amendment was an outcome after that Nirbhaya incident where a medical student was brutally beaten up and gang raped in Delhi on 16th December 2012. That incident raised protest and created shock waves national and international level. In consequence of that, the central government of India appointed a judicial committee headed by Justice J.S. Verma, who is a former judge of Supreme Court, on the 22nd December 2012 for the purpose of suggesting amendments to criminal law to severely deal with sexual assault cases. The committee submitted its report just within 29 days after it was appointed, that is on 23rd January 2013. Maximum of suggestions given by the Verma Committee report have been incorporated into an ordinance which was for the purpose of amendment into criminal laws. Then a bill of criminal law amendment was passed by the Lok Sabha on the 19th March 2013 and by the Rajya Sabha on the 21st March 2013. Then the bill received presidential assent on 2nd April 2013 and it came into force from 3rd April 2013 as Criminal Law Amendment Act, in other words Nirbhaya Act. This act came into effect with its purpose, what I mean, with the further amendment to the Indian Penal Code 1862, Criminal Procedure Code 1973, Indian Evidence Act 1872 and POCSO Act 2012. This Criminal Law Amendment Act 2013 was absolutely in victim concern if we look at in the perspective of victimology. Here I mean the amendments of provisions or sections or in the aspect of victim support, though it is especially on victims of sexual assault or sexual offences. This amendment includes insertion of new sections in Indian Penal Code. Substitution of new section against the then existing one in Indian Penal Code. Insertion of new sections and provisions in Criminal Procedure Code. And last, insertion of new sections and provision in Indian Evidence Act and POCSO Act. This act has expressly recognized certain acts as offences which were earlier dealt under different section. These new offences are like acid attack, sexual harassment, voyeurism, stalking, human trafficking. All these have been incorporated into the Indian Penal Code. The newly inserted section 166A CRPC says the public servant, if he disobey the direction of law, he shall be punished with imprisonment for 6 months to which may extend to 2 years with fine. Especially this is particular in reference with the cognizable offences punishable under the newly included offences section 326A, 326B. These are regarding acid attack, 354, 354B, sexual harassment, voyeurism, 370, 370A, trafficking of human being, 376, 376A to E, rape offences, and 5/0B Indian Penal Code. Look at here, for example, if a police is denying to register a case, it means public servant disobeying the direction under law. So in such cases, he may also be punished. Section 166B is about the punishment for non-treating a victim. It means if a hospital, either it may be private or government, irrespective of state or central government, if the hospital administration denies to admit or treat the victim of the above mentioned section, then they have to face the legal consequences, for which punishment will also be given up to 1 year or fine or both. The other new section 326A of IPC is about voluntarily causing grievous hurt by the use of acid attack. If a person victimized under this section, the person who has caused this offense shall be punished with imprisonment of either description for a term which shall not be less than 10 years but which may extend to imprisonment for life and with fine. Here we might think, how does the punishment is given to the offender is going to be helpful for the victim? Actually, the increased punishment was introduced with the aim of increasing trend of such kind of heinous crimes. So, to create a deterrent effect in the society, this amount of punishment has been provided under this section. Apart from that, the fine shall be just and reasonable to meet the medical expenses of the treatment of the victim of such offense. So the fine amount should be useful for the medical expenses of the treatment of the victim. So it will be considered by the judiciary officer how much fine would be fitting for the victim, provided the fine imposed under this section shall be paid to the victim. In the same line, if anyone attempt to acid attack on a person for which the punishment shall not be less than 5 years but which may extend to 7 years and shall also be liable to fine. Be aware of here these sections are gender neutral one and not only specifically related to any gender, though we know the women are generally the victims of such offenses. As we know, section 354 of Indian Penal Code deals about assault or criminal force to women. The newly inserted section under 54 such as 354A, 354B and others discussing about sexual harassment and an act with intent to disrobing a woman respectively. The new section 354A, I mean sexual harassment, defines the act very clearly under its various forms of sexual harassment classification, and punishment is also varyingly according to the kind of or the nature of harassment given to a woman. The definition incorporated here is actually the definition which was given under the Protection of Women from Sexual Harassment at Workplace Act 2013. Earlier, the various forms of such sexual harassment were registered only under the section 354 or sometime 509 IPC. The another new section 354B protects women against any act with the intent to disrobe a woman. If a woman made as victim by a person who has assaulted or used criminal force to her or abated such act with the intention of disrobing or compelling her to be naked, then he shall be punished with imprisonment not less than 3 years but which may extend to 7 years along with the fine. I ask you to go through the definitions clearly. The other new section 354C prohibits voyeurism. The section defines voyeurism as the act of watching or capturing a woman in private act, which includes an act of watching carried out in a place would, would reasonably expected to be to provide privacy where the victim private parts are exposed or covered only in underwear, or if a victim is using lavatory, or the person is doing a sexual act that is not a kind of ordinarily done in the public. This kind of act is seriously taken by the law, and punishment is given not less than 1 year but up to 3 years with fine. And by taking a serious note, if such kind of things are repeatedly done by the perpetrator, punishment will also be increasing, that may extend up to 7 years and shall also be liable to fine. The act stalking of women is defined and punished under section 354 of IPC. If a woman is victimized by a man who follows her and contact or attempt to contact to foster personal interaction repeatedly, though the woman shows a clear disinterest, or the man monitor the women by using internet, email, or her activity in internet or electronic communication. This is also strictly prohibited through this section. Punishment for this not less than 1 year, but which may extend to 3 years and shall also be liable to fine. Here, the important thing we have to see from victim perspective is that earlier these forms of harassments are not clearly specified in Indian law, so that punishing the offender was also not very clear. How to punish, which amount of punishment to be given were not very clear. The section 370 of IPC substituted with new section 370, which defines trafficking of person. This section penalizes the act of recruitment, transportation, harboring, transfer, or receiving a person with the purpose of trafficking him or her. We know nowadays the victims of trafficking, mainly women and children, who are trafficked for various purposes of exploitation, including sexual trade, slavery, and organ selling. The section 370 classifies various forms of section under its subsection 1 to 7, and the section 370A as well. So the punishment under these sections are ranging from at least 7 years to imprisonment for the remainder of that person's natural life, depending on the kind of offense and the number of times the offense has been committed, or the number of persons victimized. trafficking of more than one person penalized with higher imprisonment than the trafficking of one person. Likewise, trafficking of minor is an offense which has the punishment not less than 10 years but which may extend to imprisonment for life with fine. At the same time, if a person trafficked or the, the trafficking was done more than one minor person, there the person involved will be punished with imprisonment not less than 14 years but which may extend to imprisonment for life with fine. Here I ask you to take a minute to see the section and how it defines and what is the punishment and all. This section says that trafficking of minor more than one occasion will invite the higher punishment for the offender to be imprisonment for life, which shall mean the remainder of the person's natural life with fine. And also, it is to note when a public servant, as like police officer, involved or abet in trafficking of minor, the imprisonment will be for life, which mean the remainder of that person's natural life with fine. Section 370A says the punishment for exploiting a person who has trafficked will be imprisonment not less than 3 years but which may extend up to 5 years with fine. At the same time, if the trafficked person is child and again the child is exploited, the punishment is higher than the earlier one said. That means minimum 5 years which may extend to 7 years with fine. Here we can note it down. If a person exploited is a child victim, then punishment is increasing to the offender. The various circumstances with regard to offense of rape are clearly defined with separate punishments under section 375, 376. As we know earlier, section 375, section 376A to D were existing. But through this Criminal Law Amendment Act 2013, these sections were substituted with section 375, section 376A, section 376B, section 376D, section 376C, and another one section is also inserted, that is section 376E. It is very important to go through the section 375, 376 about the offense of rape, how it is modified and how it is expressed in the law in India. Section 376A, which talks about offense of rape and inflicting injury which causes death or causes the victim to be in a persistent vegetative state. In a normal expression, a persistent vegetative state is a disorder of consciousness in which patients with severe brain damage are in a state of partial arousal rather than true awareness. After a few weeks of this state or status, for example 4 weeks of vegetative state, the patient is classified as she is in a persistent vegetative state. Nowadays, as we are looking in the happenings in the country, that after the rape, the victim are severely attacked. Most probably, in such cases, persistent vegetative state may occur. In such cases, the offenders will be penalized with rigorous imprisonment, not less than 20 years, but which may extend to imprisonment for life. I mean that imprisonment for the remainder of offense, natural lives with fine. Section 376B penalize the sexual intercourse by husband upon his wife during separation under a decree of separation or without her consent. In such cases, the victim's husband will be punished with imprisonment for a term which shall not be less than 2 years but may extend to 7 years with fine. The newly inserted section 376C defined sexual intercourse by a person in authority, which actually prohibits and punish the person who is in authority involving in rape. Here, the situation of authority can be expressed like a jail superintendent under whom other women prisoners may be, or hospital authority, a doctor or any other person who is taking care of a woman, or any other such situation the woman is under authority and getting raped. For that, imprisonment is rigorous imprisonment, not less than 5 years and may extend to 10 years with fine. Section 376D talks about or deals with gang rape, where a woman is raped by one or more persons constituting a group. Each of those persons in that group shall be deemed to have committed the offense of rape, and they shall be punished with rigorous imprisonment for a time which shall not be less than 20 years but may extend to life. Here it means imprisonment for the remainder of that person's natural life with fine. Here we can see the fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. In victimological perspective, this sort of fine we can classify under the term restitution, as the monetary amount is given as a fine and received from the perpetrators. If the offences under section 376, 376A, 376D are repeated by the offenders, then the offenders will be penalized with imprisonment for life, which means imprisonment for the remainder of the person's natural life, or with death. Section 228A of IPC penalize the act of disclosing the identity of the victims of rape offences. What I mean, initially the offences are under 376, 376A to 376D. Here you can remember that I have told section 327(3) of CRPC Amendment Act prohibits disclosing the identity of the parties of rape offences. Through the new Criminal Law Amendment Act 2013, that the previous IPC sections are removed and the substituted IPC section 376, 376A to D and the new section 376E also included under this section. So anyone disclosing the identity of the woman victim of any offences under rape classification will be penalized. For your knowledge, I want to say again, as some more sections are substituted and inserted, the Criminal Law Amendment Act 2018 once again amended this section with inclusion of all the sections. Now onwards, we shall discuss the amendments made in CRPC in the Criminal Law Amendment Act 2013. The section 154 subsection 1 of the CRPC inserted with the provision. That new provision says, if the information given by a victim of acid attack related offences, sexual harassment related offences, rape offences of Indian Penal Code, then such information shall be recorded by a women police officer or any woman officer. Here I would like to point out, in the part 1 presentation we discuss about the amendment of CRPC 2008, where we saw under section 157 CRPC subsection 1, the rape victim statement shall be taken at the place of her choice as far as practicable by a witness in the presence of her parents or guardian or any near relatives. That section was about the recording of statement of the rape victim. This one is This one is about receiving information from the victims of such offences. As we know, we say the section 154 is related with the first information report. So it says if such offences are reported, then it shall be recorded by a woman police officer or any woman officer. In the same situation, if the victim is a person, woman, who permanently or temporarily, either mentally or physically able, then such information shall be recorded by that woman police officer at the residence of the person who wants to report that offence, or at a convenient place of the victim's choice or the person who want to report, whose choice, in the presence of an interpreter or special educator. The recording of such information shall be videographed. This section gives us the understanding of the state, how it takes care or assistance to the physically or mentally disabled victims of such offences. Section 309, subsection 1 of CRPC substituted with the another provision. That provision says, in every inquiry or trial, the proceedings shall be continued from day to day until all the witnesses in attendance have been examined. From this section, we can understand the criminal law of India gives importance to complete the witness examination so that it can be helpful for speedy delivery of justice, and assisting the witness is also in another way a kind of assistance to the victims of crime. The newly inserted subsection 5A of CRPC section 164 subsection 5 says that magistrate to record the statement of the victim as soon as the commission of the offence brought to the notice of the police. Here we have to note it down. This section specifically says its applicability to promptly record the statement in the cases of sexual harassment offences and rape related offences of Indian Penal Code. In such a way, the Indian criminal law takes the responsibility of delivering speedy justice in all the tracks of delivery of criminal justice system. Also, the section says if the victim or the person making statement with regard to such offence is temporarily or permanently or physically or mentally disabled, the magistrate shall take the assistance of the interpreter or special educator according to the need. The statement of the victim of offences shall also be videographed. Another two important sections which were newly inserted under this amendment are 357B, 357C. This to remind you, through the Criminal Procedure Code Amendment 2008, Section 357A was introduced, that was about victim compensation scheme. In continuation to that, 357B says the compensation payable by the state under victim compensation scheme shall be in addition to the payment of fine given by the offender to the victim under sections related to acid attack and gang rape of the Indian Penal Code. So the criminal law expects the more monetary support for the victim of such offences for their rehabilitation. So the victim compensation scheme should be separate one from the restitution to be done by the offender. Section 357C talks about treatment of victims. It asks all hospitals, irrespective of whether it is private or public, whether it is run by central government or state government, these hospitals to immediately provide the first aid or medical treatment whatever is required at free of cost to the victims of offences related to acid attack or rape offences under Indian Penal Code, which shows that the criminal justice system through its amendment takes the important of speedy recovery or speedy treatment to the victim without any obstacles, and also it obligates the hospital to immediately inform such incident to the police who is coming under the jurisdiction concerned. Here onwards, I want to start with amendments made on the Indian Evidence Act 1872, which are related with the victim consent. The section 114A substitute with a new or amended sections which says any victim of rape offense with special reference to IPC section 376 subsection 2 clause A to N. If you refer that, you can go through one by one. It says when a victim of rape says that she has not given the consent for sexual intercourse for the alleged offender, then the court should presume that she did not consent. When the question of consent, whether the woman has given consent or not, if it is arises, the court must presume that she has not given her consent, which makes the unnecessary allegation or unnecessary sufferings may be made by the defense side to be avoided with that intention for the purpose of protecting the victim from re-victimization or secondary victimization. The provision has been or would have been made. The new sections inserted in Indian Evidence Act For example, section 53A says that in the case of sexual harassment offences and rape offences of Indian Penal Code, the evidence of character of the victims or of such person's previous sexual experience with any person shall not be relevant to the present offense, so that the victim should not be put in a difficult circumstance by saying or by blaming her past character. If this happens to a victim right now, that is offense as per the Indian Penal Code, that cannot be corroborated, that cannot be blamed with the victim's past character, as there is no relevance, because that is or that was a regular strategy of the defense to put allegation on the character of the victim or showing the previous character of the victim as evidence to help the offender by the defense side. And the new section 119A of Indian Evidence Act says when a victim is unable to give his evidence orally, he can be allowed to give it in another manner, for example by writing or signs. However, such writing must be written in the open court, and this evidence is deemed to be oral evidence. At the same time, if the witness requires special assistance in the case where he or she cannot communicate verbally, assistance of interpreter shall be provided to the witness, and the all witness giving should be videographed. Section 146 of Indian Evidence Act says that adducing evidence or put questions in the cross-examination of the victim on the general immoral character of her. In the case of rape offences, the section says this sort of questions in cross-examination should not be permitted. Hereby, I like to point out the section of POCSO Act 2012. Section 42 of POCSO Act was substituted in this amendment law. The substituted act says anyone whose guilty was proved under section 166A. Here I want to remind you, this is about public servant disobeying to perform the order, or section 354 and related, that sections are about sexual harassment and rape related offences. If the person's guilty is proved under POCSO Act 2012, then comparison to be done under which act, either POCSO Act or Indian Penal Code, the punishment is greater. Then, for example, for the same offense done against a child, but the punishment in IPC is greater, then the section says he is liable to be punished with the greater degree of punishment mentioned in IPC for the same nature of offense, which is also mentioned under POCSO Act under the specified sections. This shows the child victim protection importance given by the state and criminal justice system. So, saying this, the law tries to increase the deterrent effect on the public so that the potential offender may be refrained from committing such kind of offenses against children or child victims. I like to conclude, if you have carefully looked at the newly inserted or substituted provisions of this criminal law amendment, it is well understood that the increased punishments assigned to sexual offenses or to reduce the sexual victimization by deterring the potential offenders who are in the society, and to detain the offenders for long time in the prison from the society. Also, CJS is able to punish the offenders according to the exact nature of sexual offenses committed against their victims, as the classification of offenses are made broader. For example, rape has been classified under different circumstances, sexual harassment, and other classifications are act of disrobing a woman, voyeurism, and stalking. These have been included now. The amendment gave the importance to the restitution, as restitution is in the form of fine, and the speedy treatment and speedy justice to the victims were also found as the central focus of this amended law. The next part of this presentation on the topic legal amendments related to victim consent will be on Criminal Law Amendment Act 2013. Thank you for being patient and listening carefully.